The question is as follows. Dear advocate, the mother of my child does not want me to have access to my 12-year-old child. We were never married. Last contact was in 2020. So let's deal with the facts. The last time he had contact with the child was about 4 years ago, 4 years ago in 2020. And he is the biological father of the child, but the mother refuses him to have contact with the child. What can he do? Now, when dealing with a very sensitive scenario like this, because we are dealing with a minor child, a 12-year-old minor child who last saw the father or last had contact with the father when he or she was 8 or 9 years old, quite young. Now the child is 12 years old, and the father would like to have contact with his child, and the mother refuses that from happening. Sensitive because we're dealing here with a young teenager, and whatever steps the father takes, he must be sensitive to how it will affect the minor child. I do not have much background information, the reasons why the father never had contact for the last 4 years, how much contact he had with the minor child before that. Maybe he only saw the minor child a handful of times before she turned 8 years old, etc. But in dealing with a scenario like this, we maybe have to start off with outlining the law. Firstly, in South Africa, it does not mean that you're the biological parent, the biological father of the minor child, that you automatically have parental rights and responsibilities to have contact with the child, have access and spend time with the child. Not by default. A married father, yes, of course, but not necessarily a father that was not married to the mother. There is a distinction. But if the father formed part of the child's life, paid maintenance, maintained the child, went out with the child, communicated with the child, and was there for all intents and purposes, like any normal father would be in a situation where the parties are no longer together or separated, then that specific father would have acquired parental rights and responsibilities over the minor child. But then we have a scenario where a father and a mother comes together, a child comes out of the equation, and the father goes missing. 10 years down the line, he comes out and says, I would like to have contact with my child. That scenario would not work because that father does not have any parental responsibilities and rights over the child. He can acquire it by forming part of the child's life, paying maintenance, going out with the child, communicating with the child, and so on. Then he can acquire those specific rights. But in our scenario, the email I received, I cannot assume that the specific father has acquired parental rights responsibilities or not. But let's give it the benefit of the doubt, and let's assume this father has parental rights responsibilities over the minor child. For the minor child's first 8 years of his or her life, the father was involved in the child's life. Something happened 4 years ago, and he was refused contact with the minor child. Now, just forcing contact between a father and a 12-year-old child, if contact was not exercised for the last 4 years, can be challenging and problematic, and it might not be in the minor child's best interests. More than likely, it won't be. There might be a scenario where it will be in the minor child's best interest, but generally, I would assume not. We have to traverse through this specific scenario in a very sensitive manner. If I was a father, the one step he could have done, he can approach the mother by an attorney to write the mother a letter, but it can cost money and can be very expensive. And the mother might decide just to ignore the email or the letter from the attorney. The other option which a father has and which is available to anyone out there is to approach the court. Now, there are 2 courts the father can approach for assistance. One would be the High Court. That could be very expensive as well because you require an attorney, an advocate, and so on to launch an application to court. Or the Children's Court, which I would advise would be a better court if fees are a challenge, or generally it can be a very useful court depending upon the circumstances. The children's court can order contact to take place, can order the mother to allow the father to have contact with a minor child. The children's court can also order an assessment and investigation, get the family advocate's office on board, get a social worker on board to assist in advising and educating the court on these specific dynamics regarding the minor child. The children's court might even call in the minor child and speak to the minor child. When I say the court, the magistrate might decide, I want to speak to this 12-year-old minor child who is almost a teenager, and I want to hear from the specific child why, not why, the mother must say why, but does the minor child want to have contact with the father? Let's hear what's happening over here. Or the children's court might ask a social worker to get involved, to speak to the minor child, to speak to the father, to speak to the mother, try to resolve this issue. What is the ultimate underlying problem as to why the mother does not want the father to have contact with the minor child? How did it come about? But that is looking backwards. But now we need to look forward. Once we have obtained historically why the father does not have contact, it does not mean he should not have contact going forward. It may very well be under a specific scenario for the minor child not to have contact with the father. There can be a scenario where that applies. But it can very well also be the situation where it would be in the minor child's best interest to have contact with the father, despite the history. And I always advocate the scenario that a child and a parent needs to have a relationship. It's very important that that takes place. A child with a father, despite the history. Of course, it must be in a child's best interest, but it's better to argue for a child to have a relationship with a parent than for a child not to have a relationship with a parent. Now the the father approach the court, could be the High Court. The High Court can do the same. The High Court can also appoint the Office of the Family Advocate, a social worker, or a private social worker, if the parties can afford it, to get involved in the specific case, to consult with the minor child, to consult with the father or the mother, and whoever else there are. It could be the teachers, a doctor, a psychologist, a therapist for the minor child, even going as far as speaking to the minor child's friends, family members, etc., to investigate would it be in the minor child's best interest to have contact with the father and for the minor child to be able to benefit therefrom. Now the court has done the investigation, they've consulted with the father, with the mother, the minor child, and so on, because a 12-year-old child is quite mature. And my view is when we're dealing with a child of 12 years old, the Constitution, the Children's Act, the law says the child's best interest is of paramount importance. And the Children's Act specifically says that you need to hear the voice of the child, of the minor child. Now, after having heard what the minor child said, the court will listen to what the parties had to say, and the court now ultimately will make a decision as to what is in the minor child's best interest. So the specific person that wrote me that email, my advice to you is, please, as soon as possible, approach an attorney, or go to the children's court and ask for assistance, and the children's court will assist you with the matter. It might take some time. Please be patient. You waited so long, but at the end of the day, the court will make a decision as to what is best for them.